It happened in 1130. The people of Carlisle, a town on the northern edge of England, got tired of being told what to do. They were subjects of King Henry I. His sheriffs would ride into town, collect taxes, enforce laws, and leave. The money went south. The justice served was the king's, not theirs. They had little say in how their own streets were managed or how their market was run. So they did something new. They pooled their money. It amounted to 100 shillings, a huge sum for the time. They offered this money to the king, not as a tax, but as a payment. A payment for a piece of parchment. That parchment was a town charter. It was a contract between the king and the townspeople. The king got his money in a lump sum, which he needed. But the people of Carlisle got something far more valuable. The charter granted them the right to collect the king's taxes themselves. They would pay the king a fixed annual rent called the fee farm, and anything extra they collected, they could keep. This was the start of a local budget. The charter also gave them the right to have their own local court to settle disputes. And crucially, it laid the groundwork for them to choose their own leaders to manage these new responsibilities. They were no longer just a collection of people living in a place the king owned. They were a community with legal rights. They were, in a sense, a corporation. That document from 1130 and hundreds like it granted to towns across Europe contains the seeds of the local government you see today. Your city hall, your mayor, your property taxes, the inspector who checks the restaurant kitchens all have a direct line back to these medieval deals struck between powerful rulers and everyday people who just wanted a little more control over their own lives. Number 10, the town is a person in the eyes of the law. In 1373, the city of Bristol received a charter from King Edward III. This was a big deal. The document made Bristol a county in its own right, separate from Gloucestershire and Somerset. But buried in the legal language was something else, something that had been developing for a century. The charter recognized the mayor, burgesses, and commonalty of the town of Bristol as a single legal body. A corporation. This meant the city itself, not just the people in it, could own property. It could sue someone in court. And it could be sued. Think about John Vial. He was a Bristol merchant in the late 1300s. He wasn't a mayor or a powerful lord. He was a cloth trader who did well for himself. In 1385, he decided to give back to his community. He didn't just hand out money. He bequeathed a building he owned near the harbor to the city. His will didn't name the mayor or the council members as the new owners. It named the commonalty of Bristol as the owner. The building was to be used as a warehouse, with the rent money going to maintain a nearby almshouse for the poor. This was only possible because the city was a legal person. If Bristol was just a place on a map, John Vial couldn't leave it a building any more than he could leave it to a forest or a river. But because of the charter, the city of Bristol had a continuous legal existence. The mayor would change, the council members would die, but the city itself would endure. It could hold John's property in perpetuity. Years later, if a tenant failed to pay rent on that warehouse, the city of Bristol itself, as a corporate entity, could take the tenant to court. The lawsuit would be titled something like The Mayor and Commonalty of Bristol v. Thomas the Weaver. The physical proof of this new status was the town seal. This wasn't just a pretty stamp. It was the city's signature. When the mayor and council agreed to a contract, they didn't all sign their names. They affixed the common seal, a heavy piece of engraved metal pressed into hot wax. That seal on a document meant the entire city was bound by the agreement, not just the men in the room. A document sealed in 1390 was still legally binding in 1450, long after the original signatories were gone. The seal represented the permanent legal personality of the town. Fast forward to today, look at any official document from your local government. You'll see the city seal on it. That seal is a direct descendant of the one used in medieval Bristol. When your city buys a piece of land to build a park, the deed lists the city of any town as the owner. The city, as a corporate body, owns the police cars, the fire trucks, and the city hall itself. If you slip and fall on a broken public sidewalk, you don't sue the mayor personally. You sue the city of any town. The city has its own lawyers and its own legal department because it is a legal person, constantly entering into contracts, owning property, and engaging in lawsuits. When your local government issues bonds to fund a new school or a sewer system, it is the city as a corporation that is borrowing the money. Investors lend the money to the city of any town, not to the taxpayers or the elected officials. The city's credit rating is assessed. The city is the one responsible for paying the money back over decades. This ability for a municipality to act as a single, enduring legal entity is foundational. It allows for long-term planning and investment that would be impossible if the government was just a temporary collection of individuals. It all started with those charters that gave towns like Bristol a legal identity, a seal to sign with, and the ability to outlive any single one of its citizens, just like John Vial's gift to his city did. Number 9, you're a citizen of the town, not just the kingdom. In the year 1285, a young man named Roger de Gisors arrived in the town of Norwich. He wasn't from a wealthy family. He was a weaver's son from a small village. In his village, he was a serf. This meant he was tied to the land owned by the local lord. He couldn't leave without the lord's permission. He couldn't own land himself. He owed the lord a portion of his labor. His life was not his own. But he had heard stories about towns like Norwich. He heard that if a serf could live within the town walls for a year and a day without being caught and reclaimed by his lord, he would become a free man. This was a specific right granted in many town charters, a concept known as Stadtluft macht frei in Germany, or town air makes you free. It was a radical idea in a world built on feudal obligations. Roger found a master weaver who was willing to take him on as an apprentice. For the next year and a day, Roger lived in fear. He avoided the town gates and kept his head down, worried that his lord's men would find him and drag him back to the village. But they never came. After that period passed, he was free. He was no longer the property of a distant lord. But his journey to full citizenship was just beginning. He was free, but he wasn't yet a freeman or a citizen of Norwich. To achieve that, he had to complete his apprenticeship. For 7 years, he learned the craft of weaving. He lived in his master's house, worked long hours, and saved what little money he could. When his 7 years were up, his master presented him to the guild and to the town officials at the guild hall. Roger swore an oath. He swore to be loyal to the king, but he also swore to be loyal to the city of Norwich. He swore to obey its laws, to pay his share of the taxes known as scot and lot, and to serve in the town militia if called upon. After taking this oath and paying a small fee, his name was entered onto the freeman's roll. This was a physical book that listed every official citizen of the town. Now, Roger de Gisors was a citizen. This status gave him specific rights that outsiders and even other residents of the town did not have. He could now practice his trade as a master weaver in his own right. He could open his own shop. He could buy and sell property within the city walls. And most importantly, he could vote. He could cast a vote for the alderman who would run the city. He was a participant in his own governance. He had gone from being a piece of property to a stakeholder in a self-governing community. This concept of local citizenship is the direct ancestor of modern residency requirements. Today, you don't have to be an apprentice for 7 years to become a citizen of your town, but the principle remains. To vote in a mayoral election, you have to be a registered voter living within the city limits. You can't live in a suburb and vote for the mayor of the major city next door. Your address determines your political rights at the local level. If you want to run for city council, you almost always have to prove you have lived in that city, and often in that specific district, for a certain period of time. You are a citizen of that specific place, and your rights and responsibilities are tied to it. Local governments often offer benefits to their residents. You might get a discount at the municipal swimming pool, or a lower fee to get a library card if you can prove you live in town. Your property taxes, the modern equivalent of scot and lot, pay for local schools, and your children are entitled to attend them because you are a resident. The very act of registering to vote is a modern echo of Roger de Gisors having his name written on the freeman's roll. It is a formal declaration that you are a member of the community, that you accept the responsibilities of living there, and that you claim the right to have a say in how it is run. The idea that you are not just a citizen of a country, but a citizen of a specific city or town with a unique set of rights and obligations attached to that place was born in the walls of medieval towns like Norwich. Number 8, you need a license to do that. Agnes de Gonneville was a widow in London in the year 1334. Her husband, a master silversmith, had recently died. In the rigid social structure of the time, a woman in her position had few options, but her husband had been a member of the Worshipful Company of Goldsmiths, one of London's powerful guilds. The guilds were associations of craftsmen and merchants. They were granted powers in the city's charter to regulate their specific trade. Because her husband had been a member in good standing, the guild offered Agnes a choice. She could accept a small pension from the guild's charity fund, or, if she knew the trade, she could take over her husband's workshop. Agnes had spent 20 years working alongside her husband. She knew how to work silver. She chose to continue the business. But she couldn't just hang a sign and start selling. She had to answer to the guild. The guild had strict rules, all designed to protect the reputation and economic health of their craft. Twice a year, wardens from the guild would visit her shop unannounced. They would inspect her work. They used a set of official metal plates, the trial plates, to check the purity of her silver. If she was using too much base metal, trying to cheat her customers, her work would be destroyed, and she would be fined heavily. This was the origin of the hallmark, a series of stamps pressed into silver that guaranteed its purity, its maker, and the year it was made. And the guild also set prices. They controlled who was allowed to become an apprentice, limiting the number of new silversmiths to prevent the market from being flooded. They dictated that no one could work by candlelight, not just for fire safety, but because the poor light could lead to shoddy workmanship that would damage the reputation of all London goldsmiths. If Agnes wanted to hire a journeyman, she had to hire a member of the guild. This system was a form of protectionism, but it was also a form of consumer protection and quality control. When a customer bought a piece of silver from Agnes, the hallmark from the Goldsmiths' Hall was a guarantee of its value. The guild provided a social safety net, looking after widows like Agnes and sick members. But it was also a powerful regulatory body, a government for a specific trade within the larger city government. Your modern local government is filled with the descendants of these guilds. Think about what it takes to open a restaurant. You need a business license from the city. That's the first step. Then, the health department, a specialized body of government, inspects your kitchen. They have a detailed code book specifying everything from the temperature of your refrigerator to the kind of soap you need in the employee washroom. These health inspectors are the modern equivalent of the guild wardens, ensuring a standard of quality and safety for the public. If you want to be a plumber or an electrician, you can't just start a business. You need to be licensed by a state or local board. This board, often made up of experienced members of the trade, requires you to pass an exam to prove your competence. They set standards for how work must be done, contained in the building code. This ensures that when you hire an electrician, they know how to wire a house without it catching fire. This is exactly what the Goldsmiths' Guild was doing for Agnes's customers. Professional associations like the American Medical Association or the Bar Association function in a similar way. They set ethical standards, require ongoing education, and can discipline or disbar members who violate the rules. These aren't government bodies, but they often work hand in hand with state licensing boards. The Chamber of Commerce in your town is a voluntary association of businesses, a direct descendant of a merchant guild, working to promote the economic interests of its members. The core idea that a specific trade or profession should be regulated, its quality controlled, and its practitioners licensed all started with the medieval guilds that were empowered by town charters. Number 7. The pothole in your street has a history. In 1482, the Ouse Bridge in the city of York was in trouble. The stone bridge was the city's main artery, the only way to cross the River Ouse within the city walls. It was crowded with houses and shops built directly on it. Decades of heavy cart traffic and the sheer weight of the structures had taken a toll. The central arch was cracking. The city council, the mayor, and the aldermen knew that if the bridge collapsed, it would be a disaster for commerce and for the defense of the city. The problem was money. Building and maintaining a massive stone bridge was incredibly expensive. The city's normal revenues from market tolls and court fines weren't enough for a project of this scale. But York's charter, granted and confirmed by various kings over the centuries, gave the city council a special power. It gave them the right to levy specific taxes called tolls and murages for the upkeep of public works. Murage was a tax specifically for maintaining the city walls. A similar tax could be levied for bridges. The council met in the Guildhall and, after much debate, authorized a new toll. Every cart carrying goods for sale across the bridge would have to pay a halfpenny. Every pack horse would pay a farthing. They also sent out a plea for donations from wealthy merchants and the craft guilds, appealing to their civic pride. They appointed 2 bridge masters, respected citizens, to oversee the collection of the tolls and the management of the repairs. These men kept detailed accounts, tracking every penny spent on stone, mortar, and the wages of the masons. The repair work was a massive public undertaking. It took months. The bridge masters had to hire skilled masons, organize laborers, and contract for barges to bring stone up the river. The project was funded by a combination of a user fee, the toll, a form of property tax levies on the guilds, and public-private partnership donations from merchants. This was the city government acting as a provider of essential infrastructure. They identified a public need, used their legal authority to raise funds, and managed the project from start to finish. They were not relying on the king or a local lord to fix their bridge. They were doing it themselves. This is the exact function of your local public works department. When you drive down a street and see a crew filling potholes, you are seeing the legacy of the York Bridge Masters. Your city or county government is responsible for maintaining a vast network of roads, bridges, sidewalks, and, in most cases, sewer and water lines. These are the essential public works that make modern life possible. How do they pay for it? In much the same way York did in 1482. Your property taxes are a major source of funding. A portion of every property tax bill is dedicated to infrastructure maintenance and construction. When you pay a local sales tax, some of that money goes to the general fund, which pays for road crews. Your monthly water and sewer bill is a direct user fee, just like the toll on the Ouse Bridge. You pay for the service you use. When a major project is needed, like building a new bridge or overhauling the water treatment plant, the city often can't pay for it out of its annual budget. So the city council will vote to issue a bond. This is essentially a loan that the city takes out, which it will pay back over 20 or 30 years using future tax revenue. Voters often have to approve these bond issues in a special election. This is a direct democratic parallel to the York Council debating and authorizing the funds for their bridge repair. The modern Public Works Department is a massive professionalized version of the 2 bridge masters. It employs civil engineers, planners, and skilled laborers. It uses complex machinery instead of hand tools. But the core mission is identical: to use public funds authorized by the local government to build and maintain the essential infrastructure that the community depends on. The power to do so was a key, right, that medieval townspeople demanded in their charters. Number 6, your property line is a political statement. Before the town of Ipswich received its first charter from King John in 1200, owning land was a complicated affair. If you lived outside the town, you likely worked land that belonged to a lord. You didn't own it. You had the right to use it in exchange for service or a share of your crops. The lord could take it away. Your right to pass it on to your children was not guaranteed. Inside the town, a new form of land ownership was emerging called burgage tenure. A person, a burgess, could hold a plot of land, a burgage plot, directly from the town in exchange for a fixed annual cash rent. This was revolutionary. The charter for Ipswich formalized this right. It meant that a man like Thomas the Fletcher, who made arrows for a living, could have a house and a workshop on his plot, and as long as he paid his 12 pence a year to the town, it was his. He could sell it, he could leave it to his son in his will. A distant lord couldn't just evict him. This security of property ownership was a major draw for people to move to towns. It encouraged them to invest in their property, to build a better house or a larger workshop, because they knew they would reap the benefits. Thomas's property line, the boundary between his plot and his neighbors, was recorded in the town's records. It was a legally recognized and defended boundary, but this right came with responsibilities that were also defined by the town government. He couldn't just do anything he wanted on his property. Early town ordinances, the predecessors to zoning laws, had rules born of necessity. Because the houses were built of wood and thatch and packed closely together, fire was a constant danger. Ipswich had an ordinance that Thomas had to have a bucket of water outside his door at all times. He was forbidden from having a pigsty that was too close to his neighbor's well for reasons of sanitation. He couldn't build a new shed that encroached on the public street. These were the first land use regulations. They weren't about aesthetics, they were about public health and safety. The community, through its town government, asserted the right to regulate what an individual could do on their own private property for the good of everyone. Thomas's right to his land was secure, but it was not absolute. It was balanced against the needs of the community. This is the foundation of all modern zoning and property law at the local level. When you buy a house, you receive a deed. That deed is a legal document recorded with the county or city that proves your ownership. It is the modern version of Thomas the Fletcher's name being in the Ipswich Town Rental Roll. Your property is protected. The government cannot take it from you without due process and fair compensation, a principle known as eminent domain. But just like Thomas, you can't do whatever you want on your property. Your local government has a planning and zoning department that enforces a complex set of rules. Your neighborhood is likely zoned as R1 for single-family residential. This means you can't decide to tear down your house and build a factory or a nightclub. The zoning code dictates how close to the property line you can build a garage. This is called a setback. It might specify the maximum height of your house. If you want to build an addition onto your home, you have to submit your plans to the city's building department. An inspector has to approve them to make sure they meet the building code for safety. This is the modern version of the town telling Thomas he can't have a flammable hayrick leaning against his house. When a developer wants to build a new subdivision, they must go before the local planning commission. The commission holds public hearings where your neighbors can voice their concerns about traffic, drainage, or the character of the neighborhood. The commission has the power to approve, deny, or demand changes to the project. This entire system of land use regulation, from zoning maps to building permits to planning commissions, is a direct extension of the principle established in medieval towns. The charter gave citizens secure property rights, but it also gave their elected town government the power to regulate the use of that property to protect the health, safety, and welfare of the entire community. Number 5, your tax bill is a charter, right? In 1199, the citizens of Lincoln were in a constant state of frustration with the king's sheriff. The sheriff of Lincolnshire was a powerful man appointed by the king. One of his main jobs was to collect taxes and fees from the city of Lincoln and deliver them to the royal treasury. He was not a local man. He had no loyalty to the city. His goal was to extract as much money as possible, both for the king and for himself. The sheriff controlled the local court, and the fines were a major source of revenue. He collected tolls at the city gates. He collected rent on properties owned by the king within the city. The citizens complained that he was corrupt, that his fines were arbitrary, and that the tolls were so high they stifled trade. Worse, the city saw no benefit from this money. It all flowed out of Lincoln. So, in 1199, they followed the example of other towns. And they sent a delegation to the new king, King John, with an offer. They offered to pay the king 200 marks a year, a huge fixed sum. In exchange, they wanted a charter that would give them the right to collect all these revenues themselves. This was called farming the borough. The king, who always needed cash, agreed. The charter was granted. Now, the king's sheriff had no more financial power inside the city walls. The citizens of Lincoln elected their own officials, called reeves, to do the job. The reeves collected the court fines, the market tolls, and the property rents. At the end of the year, they paid the king his 200 marks. And whatever was left over, the profit stayed in Lincoln. It went into the city's own treasury, the common chest. So this was a game changer. For the first time, the city had a local budget that it controlled. If they could encourage more trade, the tolls would increase and the city would have more money. If they managed their properties well, the rents would increase and the city would have more money. They were now incentivized to make their city more prosperous. With the money in their common chest, they could decide to pave a muddy street, repair the town wall, or hire more night watchmen. The power to tax locally gave them the power to govern locally. They were making decisions about their own community's finances. This is the direct ancestor of your modern municipal finance department. The fundamental model is the same. Your local government, whether it's a city, county, or town, has the authority, granted by a state charter or constitution, to levy taxes. And the most common of these is the property tax. Once a year, a city or county assessor determines the value of your property. Based on that value and the tax rate set by your elected city council or county board, you are sent a tax bill. This process is often contentious, with debates about property values and tax rates, just as there were surely arguments in medieval Lincoln about who should pay what. In addition, many local governments levy a sales tax, a tax on hotel rooms, or other fees. All this money goes into the city's treasury, its modern common chest. From there, the city council, through a public budgeting process, decides how to spend it. They allocate a certain amount to the police department, the fire department, the parks and recreation department, and the library. They have to make difficult choices, balancing the needs of different departments and the demands of the citizens. This entire annual cycle of assessing taxes, collecting revenue, and creating a budget is the core of local government. It is what translates political decisions into actual services. The power of your city council to set the property tax rate is the same power the citizens of Lincoln fought for in 1199. The debates at your city hall over whether to fund a new park or hire more police officers are echoes of the debates that must have happened in Lincoln's Guildhall about whether to spend their surplus on paving a street or repairing the gate. The right to local taxation and the control over a local budget is perhaps the most important power granted in any town charter, both then and now. Number 4, the health inspector is not a new idea. In 1266, London was a crowded, bustling city. Walter de Linge was a baker with a small shop on Bread Street. He worked hard, rising before dawn to bake the day's loaves, but his work was governed by a powerful set of regulations known as the Assize of Bread and Ale. This was a royal law, but its enforcement within London was the responsibility of the city government, a right secured by its charter. The assize was a complex form of price control and consumer protection. It linked the weight of a loaf of bread to the current price of grain. When grain was cheap, a penny loaf had to be heavier. When grain was expensive, the loaf could be lighter. The goal was to ensure that even the poor could afford a basic loaf of bread, and that bakers weren't profiteering during times of shortage. And Walter knew that at any moment, the city's aldermen or their appointed inspectors could show up at his shop. And they would come with their official scales, they would take one of his penny loaves and weigh it. If it was underweight, he was in serious trouble. For a first offense, he would be fined. If he was a repeat offender, he'd be dragged through the streets on a wooden hurdle with the light loaf of bread tied around his neck. For a third offense, he could be put in the pillory, a public humiliation, and banned from baking for life. The inspectors didn't just check the weight, they checked the quality. Was the bread made from wholesome flour, or had Walter mixed in cheaper ingredients like ground beans or even dirt? The city also appointed officials called ale conners, who would go from tavern to tavern, tasting the ale to ensure it was brewed properly and sold at the correct price. The city government, empowered by its charter, was deeply involved in regulating the food supply to protect the health and purses of its citizens. This wasn't a free market. It was a heavily regulated market enforced at the local level. This is the direct origin of your local government's power to regulate businesses, especially those that deal with public health and safety. The health inspector who walks into a restaurant kitchen with a clipboard and a thermometer is performing the same basic function as the alderman who weighed Walter de Linge's bread. Today, if you want to open a restaurant, a coffee shop, or even a food truck, you are subject to a host of local regulations. The local health department will have a detailed code that you must follow. It specifies requirements for food storage temperatures, dishwashing procedures, employee hygiene, and pest control. An inspector will visit your establishment before you can open to ensure you comply, and they will return for unannounced inspections just like in medieval London. If you fail an inspection, you are given a certain amount of time to correct the violations. If you have serious or repeated violations, the health department has the power to fine you or even shut you down, revoking your permit to operate. This is the modern equivalent of putting Walter in the pillory. It protects the public from foodborne illness and ensures a minimum standard of safety and quality. This regulatory power extends beyond food. Local governments have officials who inspect and certify the accuracy of scales in grocery stores and pumps at gas stations. This is the modern weights and measures department, ensuring you get the pound of ground beef or the gallon of gas you paid for. The city issues licenses for a wide range of businesses, from daycare centers to tattoo parlors, each with its own set of regulations designed to protect the public. The core idea is that when you buy a product or service from a local business, you have a right to be safe and to not be cheated. The medieval town charter gave the city government the authority to enforce this, right? Your local government exercises that same authority today every time it inspects a kitchen, tests a gas pump, or issues a business license. Number 3, your neighbor dispute belongs in a local court. In the year 1250, in the town of Leicester, 2 men named Hugh the Dyer and Robert the Chandler were in a bitter dispute. Hugh accused Robert of building a new fence that encroached on his property by 2 feet. Before Leicester had its charter, a dispute like this could have been a nightmare to resolve. They might have had to travel to the Shire Court, which met infrequently and was miles away. Or they could have been subject to the justice of a local feudal lord, which could be arbitrary and biased. But Leicester's charter, like many others, granted the town the right to have its own court. This was often called the Portman Moot or Borough Court. This court was run by the townspeople for the townspeople. The judges were the town's elected officials, the bailiffs, or the mayor. The jury, if there was one, was made up of other citizens, men who knew both Hugh and Robert and understood the local customs. So Hugh the Dyer filed his complaint at the town's guild hall. A date was set. On that day, both Hugh and Robert appeared before the bailiffs. There were no fancy lawyers. They each stated their own case. Hugh explained where he believed the old property line was. Robert argued that the old fence had rotted away, and he was simply putting a new one in the same place. They may have called witnesses, other neighbors who remembered the old fence. The bailiffs and the jury of fellow burgesses listened. They knew the properties in question. They could walk over and look at the fence themselves after the hearing. After considering the evidence, they made a judgment. Perhaps they found in favor of Hugh and ordered Robert to move the fence. Perhaps they decided on a compromise. Whatever the outcome, the decision was recorded in the borough court rolls. It was a legally binding local decision. If Robert refused to comply, the town's own constable could be sent to enforce the court's order. Justice was swift, accessible, and administered by their peers. This right to local self-justice, to have their own court, was one of the most cherished privileges a town could win in its charter. This is the foundation of our modern system of municipal and county courts. While major crimes and large civil suits are handled by state or federal courts, a huge volume of legal matters are resolved at the local level. If you get a speeding ticket, you don't go before a Supreme Court justice. You go to traffic court, which is part of your local municipal or district court system. The case is heard by a local judge or magistrate. The fines you pay go to the local government. If you have a dispute with a contractor who did shoddy work on your house for $1,500, you can take them to small claims court. This is a direct modern parallel to Hugh and Robert's fence dispute. The process is designed to be simple and accessible. You don't need a lawyer. You and the other party appear before a judge and state your cases, presenting your evidence. The judge makes a binding decision. It is local justice for local problems. Local governments also have code enforcement boards. If your neighbor is violating a local ordinance, perhaps by keeping junk cars in their yard or running an illegal business out of their garage, you can file a complaint with the city. A code enforcement officer will investigate, and if the violation is confirmed, the neighbor can be cited and ordered to appear before a hearing officer or board made up of local citizens. This is the Portman Moot in action, a panel of peers resolving a community dispute based on community standards. These local courts handle the everyday legal friction of a community. They deal with traffic violations, parking tickets, landlord-tenant disputes, ordinance violations, and small civil claims. They are designed to be accessible and efficient. The principle that a community should have the power to resolve its own minor disputes, with local officials and local citizens making the decisions, is a direct legacy of the right to have their own court that towns like Leicester fought so hard to secure in their medieval charters. Number 2, the city council meeting is an ancient tradition. In the year 1345, William de Grimsby was a successful wool merchant in the city of Chester. He was also an alderman. He was one of 24 leading citizens who, along with the mayor, formed the governing body of the city. This form of government, a council of prominent citizens making decisions for the community, was a key feature established by the city's charter. One Tuesday morning, William and the other aldermen gathered in the Pentis, a timber-framed building next to St. Peter's Church that served as the city's courthouse and administrative center. The mayor presided over the meeting. The agenda was varied. First, they discussed a petition from the city's bakers who were asking for permission to raise the price of bread because the price of wheat had gone up. A heated debate followed. Some aldermen argued that the poor would suffer. Others, merchants themselves, argued that the bakers couldn't be expected to operate at a loss. Next, they considered the state of the North Gate. The stone was crumbling, and the gate needed urgent repairs to ensure the city remained secure. They had to decide how to fund the work. Would they impose a special tax, a marriage, on goods coming into the city, or would they take the money from the city's general funds? So again, they debated. Finally, a citizen named John Lee Armorer came before them with a grievance. He complained that his neighbor was dumping refuse in the street in front of his house, creating a foul stench and a health hazard. The council listened to his complaint and then ordered the city sergeants to investigate and, if the complaint was valid, to find the neighbor and order him to clean up the mess. In this one meeting, the council acted as a legislative body debating the price of bread, a financial body figuring out how to pay for the gate, and a judicial body hearing a citizen's grievance. They were the local government. They were not ruling by divine right or hereditary privilege. They were, for the most part, elected or chosen from among the leading citizens and freemen of the town. They were accountable to their peers. Their decisions directly impacted the daily lives of everyone within the city walls. This structure and function are strikingly similar to a modern city council meeting. Go to your local city hall on a council meeting night. You will see a group of elected men and women, your modern aldermen, sitting at a dais with the mayor presiding. They will have a printed agenda, a list of issues to discuss and vote on. They will debate a proposed zoning change for a new apartment building. This is the modern equivalent of the Baker's Petition. Developers and neighborhood residents might come to the podium to speak, making arguments for and against the project. The council members will ask questions, and then, after debate, they will vote. Their vote will become a local law, an ordinance. They will then discuss the city budget. The public works director might present a report on the need for a new water main, explaining that the old one is at risk of failure. The council will have to decide if they can afford the project this year or if they need to issue a bond or raise taxes to pay for it. This is the same problem William de Grimsby faced with the crumbling Northgate. The meeting will also likely have a period for public comment. That citizens can come to the microphone and complain about anything from a pothole on their street to the noise from a nearby bar. This is John Lee Armorer bringing his grievance to the council. The council will listen and direct the city staff, the modern city sergeants, to look into the matter. The fundamental form of representative local government, a council of citizens elected to make decisions for the community, has remained remarkably consistent for over 700 years. The technology has changed. The issues are more complex, but the basic democratic process of debate, compromise, and voting by a small, elected legislative body to run the affairs of a town is a direct inheritance from the councils that were first empowered by medieval town charters. Number 1, the mayor is your town's chieftain. In 1189, London was the largest and most powerful city in England. For years, its leading citizens had managed its affairs through a council of aldermen and officials known as reeves. But they wanted more. They wanted a single leader, a figurehead who could represent the city's interests to the king and who could act as its chief executive. They wanted a mayor. That year, during the turmoil surrounding King Richard I's coronation and his need for money for his crusade, London secured the right to have one. The man they chose was a wealthy draper named Henry Fitz-Aylwin. As the first mayor of London, Fitz-Aylwin's job was a combination of things we would recognize today. He was the chief executive of the city. He presided over the meetings of the aldermen, setting the agenda and guiding the debates. He was responsible for making sure the council's decisions were carried out. If they decided to hire more watchmen, it was his responsibility to see that it was done. He was also the city's chief magistrate. He sat as the head judge in the city's main court, the Court of Houston. He heard the most serious cases and had the power to impose fines and imprisonment. He was the ultimate enforcer of the law within London's walls. That his authority gave weight and finality to the city's justice system. And crucially, he was the public face of London. When the king needed to negotiate with the city for a loan or a tax, he didn't meet with 24 different aldermen. He summoned the mayor, Henry Fitz-Aylwin. Fitz-Aylwin spoke for the city. He was its representative, its advocate, and its leader. He held the office of mayor for 24 years until his death in 1212. During that time, he established the mayoralty as the central, powerful, single office of executive authority in the city's government. This model of a single elected executive for a town or city was so effective that it was copied by towns all across England and Europe as they gained their own charters. This is the most visible and direct link between medieval charters and your local government today. The person you elect as your mayor, city manager, or county executive is the direct descendant of Henry Fitz-Aylwin. The form of mayoral power can vary. In a strong mayor system, the mayor is the city's true chief executive, much like Fitz-Aylwin. They appoint department heads, the police chief, the fire chief, the planning director. They prepare the annual budget and submit it to the city council for approval. They have the power to veto ordinances passed by the council. They are the person in charge, the one who runs the day-to-day operations of the city. In a weak mayor or council manager system, the mayor's role is often more ceremonial, more like a chairman of the board. They preside over council meetings and act as the public face of the city, but the chief executive is a professional city manager hired by the council. The city manager handles the day-to-day operations, and department heads report to them. Even in this system, however, the mayor is still the political leader of the community, the one who often sets the policy agenda and represents the city to the state and federal government. Think about the functions of your local mayor. When a major company is thinking of moving to your town, they meet with the mayor. When a natural disaster strikes, it is the mayor who is on television, coordinating the response and reassuring the public. When there is a ribbon cutting for a new library or a new bridge, the mayor is there with the giant scissors. They are the public embodiment of the city. They are also the political focal point. When citizens are angry about rising taxes or a crime wave, it is the mayor who often bears the brunt of the criticism. They are the one ultimately held responsible for the performance of the city government. This idea of a single, accountable executive at the head of a local government, a leader chosen from and by the citizens to run their city, was a radical innovation established by those first town charters. Henry Fitz-Aylwin would recognize the core duties, pressures, and responsibilities of your mayor today.